Hello and welcome back to Nairobi Legal Insights. In our video today, we're going to be focusing on tenancies, specifically the enforcement mechanisms by landlords against tenants. Now, I've received a lot of questions on matters tenancies, and I'm going to be creating content in this area so that we are able to understand the rights and duties of landlords and also the obligations tenants have towards landlords. In this specific video, we're going to be in a position to understand what amounts to unlawful eviction, the action landlords can take in order to recover rent arrears. We're going to also be looking at forfeiture, and here what I mean is that this is the right to regain leased premises. So if person A rented out the apartment to you, at what point can they actually be able to take it away from you legally? And we're also going to be looking at distress for rent. Basically, how do you recover your rent from a tenant who still lives in your premises but they have failed to pay that rent? So stay tuned as we continue on this topic of tenancies. The first enforcement mechanism by landlords against tenants is what we call the distress for rent. And in Kenya, we have the Distress for Rent Act, Cap 293, which provides, or rather gives a landlord the right to remove certain goods from the possession of a tenant as a way of compelling that particular tenant or forcing them to pay rent that is due. So here I'm coming to take away your goods because I'm compelling you to actually pay the rent you are supposed to pay. So specifically under section 3.1, you will see that it provides for a remedy by distress for recovery of rent, and this remedy does not actually require a court order. So once these goods have been taken away from the tenant, then the tenant is within 10 days supposed to actually pay rent. And if that rent arrear has not been paid, then the landlord can go ahead and sell the seized goods by way of public auction. And you might have seen instances where auctioneers are sent into a tenant's premises and they take out goods, and those goods are taken away or they're removed from the possession of a tenant because the landlord is trying to force that tenant to pay rent that is due. However, we need to note that there are certain exceptions when it comes to carrying away certain goods from a tenant's premises, one of them being that you cannot carry away tools of trade. And when I talk about tools of trade, what I mean here is that these could be equipment that someone uses to earn a living. Yeah, it could be your computer, it could be your desk, depending on your trade, that if you don't have this equipment, then you cannot be able to make any money. So I'll be expounding on these exceptions that arise as far as distress for rent is concerned in more videos to come. But the essence here is that you need to note that a landlord at all times has the right to remove certain goods from the possession of a tenant as a way of compelling that particular tenant to actually go ahead and pay rent. Now, the act I've just stated right here, or provided right here, you can be able to access it on Kenya Law Resources, download a copy, and you can be able to read through the act so that you get to understand how the Distress for Rent Act, Cap 293, works in Kenya. The next enforcement mechanism is what we call forfeiture. And when we talk about forfeiture, this is a right to regain leased premises. So when you rent out a house, you need to remember that what you have is possession of that house, not ownership. There's a clear distinction between ownership and possession. When you are a tenant, the landlord reserves the right to actually get back their premises. Now, even when you're paying rent, a landlord could just wake up one day, give you notice that they intend to have back their premises, and so legally you have to hand over the premises to the landlord. Remember, all you had was possession, not ownership. Now, to break this further, the landlord can be able to re-enter his premises simply because the tenant has breached a certain covenant that was actually put within the lease agreement. So some of the covenants in the lease could be that maybe there's a restrictive covenant. Do not use my apartment as a club. Do not use my apartment as a brothel. And the tenant goes ahead to breach those covenants. In this particular instance, the landlord has a right to regain the leased premises from the tenant. Number two, the other alternative is that you could have done nothing. Maybe you've done nothing wrong, you've been paying your rent. Still, the landlord has a right to regain the leased premises because, as we discussed earlier, all you have is possession and not ownership, meaning that once particular rules are followed as far as forfeiture is concerned, then the landlord can be able to regain or get back his or her leased premises. And remember that the right to forfeiture must be done in accordance to the law. Specifically, when we talk about the law, I'm referring to the Land Act section 73 to 75, and we're going to be expounding on these sections so that you understand what constitutes the right to forfeiture and what rules must be followed. Because of the intensity of how to exercise forfeiture or how to regain back leased premises, I'll create a special video for this particular question, how to exercise forfeiture. So simply subscribe to receive notifications the next time I will post a video on how to exercise forfeiture. But in the meantime, I want us to move on to unlawful eviction so that we understand what amounts to unlawful eviction, and thereafter we're going to discuss action for recovery of rent arrears. When it comes to unlawful eviction, we refer to the Land Act 2012. You can download this act online so that you read and understand what amounts to unlawful eviction. So the key point I want you to understand from section 77 of this act is that the moment you've been unlawfully evicted from a particular premise, then you will be immediately relieved of all obligations to pay rent or any other money that is due. So unlawful eviction equals non-payment of any amount of money that is due. And this is in regard to section 77 of the Land Act. Now, as far as unlawful eviction is concerned, as you read further, section 77(2) provides that there could be some sort of constructive eviction. An example would be that maybe you entered into an agreement to enter a certain premise and you've not actually been able to obtain possession for that matter as a result of the inaction of the lessor. Remember, the lessor is the person who hands over the lease to you. So to understand, you might have seen the words the lessee and lessor. A lessee is the person receiving an apartment. Maybe you've leased out an apartment, then you're the lessee. Then the person handing it over to you, the owner, is the lessor. These are just legal terms, but just to simplify this for you, the same way we have an employer-employee, here we have a lessor and a lessee. So provided that a lessee who is aggrieved as a result of unlawful eviction under this particular section, which is 77 of the Land Act 2012, that person who has been evicted unlawfully may commence an action against the lessor for remedies. Remember, if someone evicts you unlawfully, then they have to pay for that action. And here you'll be seeking remedies. Now, to understand eviction further, I'll also be expounding on it in more videos to come. But basically, the key point here is once you are evicted unlawfully, then immediately you shall be relieved of all obligations to pay rent. One might be wondering whether a landlord needs a court order in order to evict a tenant. And the answer here is that if the tenant is in possession of your premises, then you need to give them notice. And if they do not comply with that notice, then you can proceed to court pursuant to section 73(2)(b) of the Land Act. Remember, I told you the Land Act of Kenya 2012 can be accessible online. So basically, you've given the person notice, they have not complied, then you proceed to go to court because they're still in your premises and you're seeking a court order for them to vacate your premises. So, legally speaking, there are certain requirements that must be fulfilled as far as giving notice is concerned. And these requirements will be covered in more videos to come. All you need to do is to subscribe so that you receive notifications every single time I will be posting a video in line with tenancies as far as Kenyan laws are concerned. And just to take you back, when we talked about forfeiture, forfeiture meant regaining possession of leased premises. You lease out your premises to someone. How do you regain your premises back from them? When it comes to instituting an action for recovery of rent arrears, what you need to know as a tenant, if you've lived in someone's premises for maybe 7 months, you only paid for 2 months, then carried a few of your personal belongings and ran away, leaving a few things in the house. It could be a bed and a fridge. The landlord has up to 6 years to actually institute a claim against you to recover rent arrears, meaning that within a window period of 6 years, the landlord can still come after you. And this is in accordance with the Limitation of Actions Act Cap 22. And this act can also be downloaded online. So basically there is a period of 6 years within which a landlord can come after you. So maybe more of a practical example, imagine Anne has been living in Cleleshwa for a period of 7 months, and there is, of course, rent has accumulated. Anne cannot afford to pay the rent. The rent is now amounting to 400,000 after those 7 months. In this particular instance, the landlord chooses to take some of Anne's goods to recover the rent arrears, and it is so discovered that actually the value of the property in Anne's premises is only 120k. So as you can see, out of the sale, the landlord can only recover 120k out of the 400,000 which Anne is supposed to pay in rent. Now, Anne goes ahead to disappear at night with a few of her personal belongings, hoping that she will never be able to pay the landlord. In this particular instance, Anne as a tenant should know that the landlord has up to 6 years to actually go and institute a claim against Anne for recovery of rent arrears. So if it's beyond 6 years, then Anne might be safe. If it's within a period of 6 years, the landlord has an option to still institute an action for recovery of rent arrears. Remember, even after selling the property worth 120,000 in value, there was still a balance, and Anne left with that balance. So the landlord will still have an option to institute a claim for recovery of rent within a period of 6 years. Now, as you can already see here, this only occurs where Anne's seized goods or property were already sold, but that money was not sufficient to cover the rent arrears, as you can see. So you cannot actually run away with a landlord's money. Even when you leave some property back, that property can be sold. If the value does not amount to the total rent, then the landlord can come after you for a period. There's a window of up to 6 years when you can be sued. Maybe you've not been sued for the past 4 years. The landlord still has 2 more years to come after you to recover the rent arrears. And this is what the law provides for as far as action for recovery, or rather, as far as action for recovery of rent arrears is concerned. The points in this particular slideshow are just to emphasize that walking away with a landlord's money is never a safe option, because the landlord can still institute a claim to recover the rent arrears from you, even long way after you're gone. The other thing we need to note is that we have a business premises tribunal and the rent restriction tribunal. And the moment you leave the landlord's premises, then as a tenant, you can no longer access these tribunals. Some people could be going to the rent restriction tribunal to raise a point of concern. Maybe your rent has been increased and you're living under controlled tenancy. And when I talk about a controlled tenancy, these are things we're going to discuss so that you understand what amounts to a controlled tenancy and uncontrolled tenancy. As a tenant who falls under controlled tenancy, then your landlord cannot just increase rent. And these are things that are going to become clearer as more content is created along the way. One of the key things you need to take away from this video is that the landlord-tenant relationship can come to an end at the discretion of the landlord. So even if you've been paying your rent on time, one day your landlord could decide to send you notice to vacate the premises. And provided that notice is sufficient and legally followed, then you have to vacate the premises, because When you're renting out someone's apartment, all you have is exclusive possession of that apartment and not ownership. Ownership belongs to the landlord, and he has the discretion to actually end the tenancy by giving you sufficient notice. So that is one key point we need to remember. In our next video, we're going to be looking at the rules to be followed when it comes to forfeiture. Remember, we said forfeiture is the right to regain leased premises, basically what process should be followed, and I'd stated that I will be expounding on section 73 to 75 of the Land Act of Kenya 2012, and we will also look at what amounts to a controlled tenancy or an uncontrolled tenancy, and we will be in a position also to understand what is a lease and how does it differ from a license. Thank you so much for watching. Continue again to subscribe and turn on the notification bell so that you receive notifications every single time I'm going to be posting a new video on tenancies. For active engagement, you can follow us on Twitter. Our Twitter handle is @Nairobi_legal. Thank you and see you next time.